Hey everyone, my name is Herschel, and I'm thrilled to have you join me today as we embark on in-depth exploration of some of the most critical topics. Okay, at the intersection of digital evidence, privacy laws, and forensic investigations. So, guys, over the next hour or so, I'll take you on a journey through issues that actually directly impact our everyday digital lives. I mean, we'll examine everything from how evidence is collected and circumstances under which legally obtained material might or might not be used in a court, uh, to how our privacy expectations are safeguarded on our computers, whether we are on work or at home, I would say. So here we are. We'll also, explore how international cooperations, like through treaties, enables law enforcements to access cross-border evidence in our increasingly globalized world. And in addition, I'll also explain the intricate balance between the privacy and the security. So explain this, I would say significance of the privacy impact assessments, PIAs, in mitigating data risks, and wrap up with a detailed case study on PHIPA investigation that challenges our assumptions about data collections and mass surveillance. So throughout our discussion, I'll share like uh, insights drawn from key court cases and doctrines. Okay, so seamlessly connecting these elements to illustrate how each contributes to a framework that both protects our rights and empowers law enforcement. So let's get started. Okay. Okay, so I'm going to walk you through one of the most debatable questions, okay, in our legal systems. Can evidence that is illegally searched and seized be admitted in court? And as we look at this side, okay, notice that the answer isn't simple yes or no, I would say. It actually, depends on the circumstances. And I'll explain this by first exploring the US perspective and then the Canadian perspective. So let's move to US perspective. Okay, so let's start with the United States first. Okay, so our system is built on a strong protection of the Fourth Amendment. Okay, which guards against unreasonable searches and seizures. As you can see on the slide, okay, the sorry, my bad. The exclusionary rule set out in C 1961, as mentioned over here, generally bars evidence gathered through, unconstitutional means from being used in a court. So let's talk about the good faith exception. Okay. So in United States versus Leon, 1984 case, the court held that if officers act under honest belief that they have a valid warrant, even if that warrant is later found be defective, the evidence may still be admitted. And this exception is designed to prevent technical errors from unduly hindering a case when there was no malicious intent. So that was all. And moving on, we have inevitable discovery doctrine. Okay. So as shown here, Nix versus Williams, 1984 case. Um, so here what happens is if evidence would have been discovered by lawful means, regardless of the initial illegality, so its exclusion might not serve the interest of justice. Okay, so this doctrine recognizes that sometimes evidence is bound to uncover, and excluding it could obstruct the truth, I would say. Okay, next, let's consider attenuation doctrine. Okay, and as we can see over here in Utah and Striff 2016 case, The court explained that if the connection between the illegal search and evidence is sufficiently weakened by intervening factors, the taint of the initial violation may dissipate. Okay, and the evidence can then be admitted. So basically, this shows that the legal system carefully weighs how direct the link is between the misconduct and the evidence. So, lastly, there is, as you can see over here, sorry, my bad, impeachment exception. So, although evidence obtained legally is generally excluded from the prosecution's case, it may still be used in impact defendant's credibility if there is a testimonial in is actually inconsistent, if it's the case. And this actually ensures that even if evidence cannot be used directly, it still serves a vital role in ensuring truth in the courtroom. That's the scene. Okay, so that was all about the US perspective. Now let's move to the Canadian perspective. So let's shift to the Canadian perspective finally. Okay. So here's our approach as defined by the Canadian Charter of Rights and Freedoms. As indicated on this slide, Section 8 guarantees that every person has the right to be secure against unreasonable searches and seizures. Okay, so while Section 24(2) instructs court to exclude the evidence of obtained in the violation by the charter rights of its admission would, say, bring the administration of justice into dispute. And I would say, in the case of Regina versus Grant in 2009, the Supreme Court of Canada refined a balancing test that considered the three factors. The first one is the seriousness of the rights breach. The second is the impact of the breach on the accused rights. And lastly, society's interests, okay, in the effective prosecution of the crime. And although Canadian laws doesn't specify specifically, call it a good faith exception. The courts to assess and conduct of a police. Okay, a minor of as I remember, okay, a breach might be treated differently from a flagrant violation, and ensuring that the response is proportional to the offense. Okay. So basically, that was all about this particular Canadian perspective. Moving to the next slide, as we can see over here. Okay. Um, it actually became afterwards. It actually became clear that both the U.S. and Canadian systems strive to, protect individual rights while allowing the flexibility for effective law enforcements. So that was all the case. So, in the US, doctrines such as a good faith, inevitable discovery, and attenuation exceptions ensures that the exclusion of evidence is not absolute. Okay, when honest mistakes occurs or when evidence is bound to be discovered regardless. And in Canada, I would say the charter-based balancing test services, serves uh, a similar purpose somehow, and ensures that while a breach of a right is taken seriously, and it doesn't mean and necessarily obstruct the pursuit of justice if the breach is is minimal. So in essence, both the systems operates on the principle that evidence should only be excluded when its inclusion would fundamentally, underline the justice. But they also recognize that sometimes a strict application of the rule could let important evidence slip away, and therefore hindering the truth-seeking process. So that was all. And wait a second. Moving to the next slide, let's explore how our legal system applies to reasonable expectations of privacy. Okay, tests to computer systems and digital data, particularly under Canadian laws. Okay. So, let's talk about privacy at in the workplace first. So when we use work devices, many of us assumes that because of the laptop or smartphone provided by our employer, our privacy might be limited. So, however, in Regina versus Cole 2012 case, as mentioned over here, the Supreme Court of Canada made it clear that even though the device is employer issued, we still maintain a reasonable expectation of privacy regarding the personal files stored on it. Okay, so think about it. Okay, many of us check personal emails, store photos, or even uh, jot down private notes in our work laptops. So, even with the employer, monitoring policies, in every places, the court recognized that these personal data element should be protected. And for me, this actually resonates strongly because I often find myself toggling between work and personal use on the same device, right? And I believe that while employers must ensure that the security and proper functioning of their system, they should have a carte blanche to pry into our personal lives. So our personal data is an extension of who we are, and even in the work settings, it deserves careful legal protections, right? So moving to the next slide, privacy at home. So that was all about privacy in workplace. Now let's talk about the privacy at home. So here our expectation of privacy is even more robust, right? In Regina versus Wu 2013 case, the Supreme Court actually stressed that general warrant for a home search doesn't automatically give a law enforcement the authority to search every digital device found within. Okay, so your personal computer, smartphone, or tablet isn't just a piece of hardware. It's where you store everything from sensitive financial records to private family photos and I would say personal communications, right? So imagine your home computer. It's like a modern diary that holds detail you'd never want to expose without a very specific legal reason, right? So the court's decision in Wu means that any search of these devices must be narrowly tailored, right, and specifically authorized by a warrant. So this protection is crucial because it actually upholds our expectation that our personal private lives remains just the private, right? And I personally value my home devices. Okay, and I work over there, relax, and store my most of the personal data over there. And I take comfort in knowing that the law actually requires a precise judicial order before anyone can search them. So it actually reinforces the idea that our personal space is inviolable. Okay, and I would just say that let's consider interesting overlap. Okay, over here. Sorry for that. So between these two realms. So many of us, use the same device for both work and personal tasks, which means our digital lives are not neatly separated, I would say. And Canadian law actually recognized this overlap by providing a diminished but still a significant expectation of privacy for work device, while holding a personal home device to, I would say, much higher standards. Okay. For an example, I would say if you use your work laptop for personal emails, you are aware that there might be some level of monitoring or oversight for company related purposes, right? And however, the law ensures that the personal files are not a subject to an indiscriminate search without a specific warrant. So, this actually balanced approach is designed to protect your personal data while still allowing employers to maintain their systems for legitimate businesses. Okay. So, and I often think that this legal framework is not just abstract of a principle, but something that directly impacts our day-to-day lives, and it gives us confidence to our use of devices without fear that personal world will be arbitrarily invaded, right? Moving to the next international perspective. Okay, so let's now compare how the reasonable expectation of a privacy is applied. Okay, with respect to police searches in both United States and European unions. Okay, so sorry, in the United States over here, as you can see, the concept of I mean, the reasonable expectation of privacy is firmly established by the U.S. legal framework. Okay, notably, I mean, Katz versus the United States in 1967 case. So, in that landmark case, the Supreme Court stated that the Fourth Amendment protects people, not places. Okay, by recognizing that even an individual has a subjective expectation of privacy, and that expectation is one society deems reasonable, then any government intrusion must be justified with a warrant or fall under recognized expectation. Okay, so this principle has has since been adapted to address modern issues such as digital communication and location tracking. Okay, ensuring that police searches remain subject to strict judicial oversights, right? And in the meantime, while the EU at the same time does not explicitly use this particular term, okay, reasonable, yes, reasonable expectation of the privacy. They both are different, okay, in their way. So the protection of a privacy is deeply embedded in its legal framework. So okay, so under Article 8 of European Convention on Human Rights, um, every individual is entitled with respect for their private and family life, their home, and their, I would say, correspondence. So this means that any interference by the state, such as police search, must be both necessarily proportionate and must be carried out in accordance with the law. Okay, so this framework effectively serves same purpose as the US standards by ensuring that the government actions are justified by high standards of necessity and proportionally, right? And I would say by examining these two approaches, I mean, we see that both the systems are committed to protecting individual privacy during police searches, though they articulate the standard differently. Okay, in the US, there are reasonable expectation test is clearly defined. Okay, that direct influences that actually directly influences the Fourth Amendment. Uh, Okay, and in the European judiciary, privacy is safeguarded as a fundamental human right. So, I mean, through strict requirements for necessity and I would say proportionality. Okay, that actually ensures any state interference respects the dignity and privacy of the individual. So now let's dig deep into when Canadian authorities need search warrants to examine suspects' computer and explore the exceptions that have emerged over time. Okay, so the general rule, let's talk about that first. So Canadian courts have been unequivocal because digital searches can be exceptionally intrusive. Police are generally required to obtain a warrant before searching computers. So this stem from the understanding that our computers are unique repositories of a vast amount of personal data, ranging from sensitive emails and private photographs to, I mean, detailed personal records. This actually presumption is that any warrantless search risks violating the Section 8 of the Canadian Charter of Rights and Freedoms, which protects us against the unreasonable searches and the seizures. Okay, so and I would say just both are the necessary and logical. Okay, so the digital because I would say the digital footprints on the computer is not just information. It has every single thing. It's the essence of who we are, as I already told you, right? So, without a strict judiciary oversight, the potential of, I would say, abuse or overreach is simply too high. Okay, so that was all about that. So let's consider cases. Okay, let's talk about that where Canadian courts have clearly ruled that warrant was indispensable. Okay, let me first talk about the Regina versus Reeve 2018 case. So, in this case, even though a computer was taken with the consent of a spouse, the Supreme Court held that the police still needed a warrant. Okay, the reasoning was that the privacy interests the accused could not simply be sorry, it could not simply not be I mean waived by a third party, or I would say without a consent. So this ruling underscores the idea that personal privacy is so important that even the indirect permissions cannot override the need for the proper legal processes. Right. Let's now talk about the Regina versus Cole 2012 case. Okay, I already mentioned that once. So here the police conducted a forensic search of a teacher's work issued laptop without obtaining a warrant. So the court found this action unconstitutional because despite the device being employer owned, the teacher maintained a reasonable expectation of a privacy over his personal files. So this decision reinforced that even in the workspace where some level of monitoring might be expected, the boundaries are personal privacy cannot be dismissed without a judicial scrutiny. Okay, so these cases actually highlights a core principle regardless of who owns the device or who gives consent, right? So this search of a digital device requires a CAD for, judicial consideration due to the deeply personal nature of the data involved, right? So that was all. Now let's talk about Regina versus Furin 2014 case. So in this case, the court actually permitted a limited warrantless search of a cell phone incident to to a lawful arrest. Okay, so the rationale here is very specific, I would say. The search must be narrowly confined to addressing immediate safety concerns and preventing the destruction of the evidence. Um, I would like to say that this exception acknowledges that in some situations, waiting for a warrant could result in a loss of critical data, like if a suspect is about to delete incrementing texts or photos, right? So let's take a broader perspective from this. Okay, so historically under a Customs Act, wait a second. Sorry for that. So historically, under the Customers Act, border officers were allowed to search electronic devices as travelers crossed international borders. So, based on the idea that crossing a border diminishes one's privacy expectations, right? So, however, more recent decisions, such as those in, I would say, Regina versus Canified, okay, 2020 case, and Regina versus Pike 2024 case, suggest that even these expectations are being re-examined. So now there is there's a growing, I would say, insistence that warrantless searches at the border must be increased sensitively around digital data, and the growing expectation that our privacy should not be, compromised simply because we're traveling. So in both the exceptions, the court have been very caution. They acknowledge that while emerging circumstances of or unique border scenarios might be necessarily prompt actions, such measures must be strictly limited and subject to subsequent judicial reliefs. And I personally, believe that I actually appreciate that the Canadian courts have been evolving in their approach, especially with their broader searches, where traditional assumptions about the privacy are being re-examined in the light of modern technologies. So this evaluation actually signals a positive trend as our digital lives become more computerized, and our legal safeguard must be, accordingly. So that was all for. So now let's talk about essential aspect, okay, of our digital investigations, uh, exigent circumstances. So in today's rapid digital world, evidence can vanish in mere second. If not, uh, preserved immediately. Here I'm gonna tell you about all this stuff. So like Canadian law addresses this, all these emergencies in the context of digital forensics, and let's trade this with detailed examples as well. So this is the definition of accident circumstances in digital forensics, and accident accident circumstances refers to those critical moments when police are allowed to bypass that usual requirements for obtaining a search warrant, because there is an imminent risk of harm, danger to life, or we can say destruction of evidence. So, as mentioned over here, under section 487.11 of the Criminal Code, if enforcement determine that waiting to obtain a warrant would result in the loss of essential digital evidence, they are authorized to conduct a immediate limited search to preserve that evidence. Okay, so actually, this legal provision is designed to ensure that the dynamic and volatility nature of digital data does not obstruct the administration of justice. So imagine a situation, okay, where a suspect is actively deleting files or encrypting data on their computers. So, in such scenarios, even a delay of a few minutes or a few seconds could render a crucial evidence, uh, right? So, I would say the law recognizes that while securing a warrant is the ideal process, and emergencies sometimes demand rapid action to safeguard the integrity of an investigations. So now let's talk about Regina versus Peterson 2017 case. Um, Consider the case of 2017, right? It serves as a clear illustration of how exigent circumstances function in the practice. So, in this case, court scrutinized claims of urgency with a great care, and the investigation had received credible intelligence suggesting that the suspect was on the verge of remotely wiping the content of their computer. Okay, a move that would destroy invaluable digital evidences. So, as you can review the detail on the slides, so think about stake involved. Okay, in a situation like this, waiting a standard time to obtain a warrant, even if it's just a few minutes, could mean the permanent loss of key evidence. right? So the court's decision in this petition underlined that the exigency exception can only be invoked, okay, when there is undeniable proof of imminent risk. And in the other word, I would say law enforcement must provide clear, objective evidence that any delay would result in the destructive or alternation of our digital data. And this case actually demonstrates that the law permits immediate actions only when absolutely necessary, and that such actions must be strictly limited to preserving evidence at risk. So the search conducted under exigent circumstances is meant to be narrowly focused response. I mean, designed to solely to compare and secure the volatility data before it's I mean it lasts forever. Okay, that was all about that. Now let's talk about balancing rapid response and judicial oversights. Okay, so this is a critical tool in a digital forensics, but its use is careful and circumstantial. Okay, so on the other hand, there is a compelling need to law enforcement to act swiftly when the threat of a data destruction is real, and that digital evidence can be extremely fragile, and a suspect action such as initiating an auto deletion sequence can erase months of years of informations in a second, in a fraction of a second. And on the other hand, the power to bypass the warrant requirements cannot be, I mean, taken lightly. So for me, it's delicate balance. On one hand, we need to flexibility to act in the real time when evidence is on the brink of being lost, and on the other way, we must protect our fundamental rights against unwarranted intrusions. Like the key is ensuring that the exigent circumstances are invoked only when there is a undeniable proof that waiting would destroy evidence, okay, and endanger, I mean, lives, critical lives. So that was all about exigent circumstances. Let's move forward to handling privileged informations. Okay, so this is actually focused to an issue that absolutely critical for the fairness of our legal process, I would say. So, what happens when a forensic investigator encounters privileged information during a digital search? So, this topic is actually close to my heart because it underscores, I mean, the importance of protecting the sanctionality and the lawyer's client's communications, which is fundamental to, I mean, ensure that everyone has access to the effective legal representations. Okay, so let's first see the steps: immediate cessations, segregations, and etc. etc. So let's understand the legal framework. So in Canada, solicitor client privilege is considered sustenance, and this principle is just so fundamental that it actually protects even the most sensitive communication between a lawyer and the client, ensuring that the legal advice promise their process remains confidential at every point of time. So the guidelines established in the Lavie versus Canada, I mean Attorney General. This case was in 2002, as I remember. So these things are clear. If the investigators come across the material that appears to be protected by privileged during a search, they must be immediately halt their examination of their material. Okay, so let's talk about practical steps, privileged materials. I break down the steps over here. So let me first talk about the immediate cessation of examination. So as soon as there is an indication that a file or a folder contains a privileged content, the investigator must be cease further examination, right? So this immediate pause is critical because continuing the search could lead to unauthorized exposure of sensitive information, right? Second is segregation and secure storage. Okay, so this means copying or isolating the suspected privileged data in a secure manner and ensuring that that is separated from the rest of the evidence and cannot be accidentally. So in practice, this might involve transferring the files to an encrypted drive or flagging them in a secure system that only designated persons can access. Okay. Third is notifying supervising authorities. So this notification triggers the process whereby a judge or an independent third party, often referred to as a special master or a neutral reviewer, like it will examine the material to determine whether it is near privilege. I mean, this step is vital to ensure that the rights of the individual are preserved and that any potentially inevitable information is properly set aside. Right. So we talked about all threes, and from my perspective, I mean, these procedures are just legal formalities. I mean, they are the bedrock of our justice system. I firmly believe that that lawyer-client privilege must be preserved at all costs. And imagine if every confidential communication between a client and their lawyer could be assessed by an investigator during a search. Not only would it deter the people from seeking legal advices, but it would also fundamentally, I mean, undermine the trust that is essential for a fair and legal process. So, this approach also ensures accountability when I would say investigators immediately stop and secure any material that might be privileged. I mean, it creates a clear record of their actions. I mean, should any dispute arise and later about whether the privilege was breached, I mean, there is a documented evidence that the proper procedures were followed at that moment. So, uh, this is not only protects the rights of individual involved, but it also upholds credibility of the investigative process as well, right? So let's talk about mutual legal assistance. Okay. So in today's globalized world, crimes often transcend nation boundaries, making the exchange of evidence between countries essential. So this is where the mutual legal I mean, assistant treaties (MLTs) come into play. So let's talk about how it works first. So an MLT, an AMLAT is a formal agreement between the countries that allows law enforcement agencies, I mean, to request assistance in gathering evidence from another jurisdictions. And for example, let's say if Canadian authorities are investigating a case involving international human smuggling, they might need evidence from a foreign country where part of the crime occurred in, let's say, Regina versus Rajratnam. Okay, so Canadian investigator used AMLET to obtain records from Thai authorities, illustrating the power of these treaties in bridging international legal gaps. So, what's the importance of that? Okay, it actually ensures that the evidence is collected legally and in a manner that is admissible in court, while respecting each nation's legal process and sovereignty. So they help to prevent situations where evidence might otherwise be obtained by bypassing a country's judicial safeguards. And I see that this is an essential tool for modern law enforcement in an era where cybercrimes and transaction crimes are rampant. So, no single country can effectively combat these issues alone. Okay, so that is why AMLATs promote international cooperations and upholds the rule of law across the borders and necessity for fair and just global systems, right? So let's move to the next slide. Moving to the next slide, let's broaden our scope. Okay, uh, let's discuss three key privacy principles that many uh, jurisdictions worldwide have embraced, like principles that extended beyond the traditional 10 found in Canada's privacy framework. Okay, so the first is PBD, privacy by design. So under this Article 20, under Article 25th of the Europeans GDPR, uh, privacy by design requires organizational to integrate privacy measures and into the very architecture of their system right from the start. So, in practice, this means that when a company develops a new software platform or a digital service, it must consider data protection at every stage, and it ensures that privacy isn't merely added as an afterthought. Okay, for instance, robust encryption, minimal data collection, and user-friendly consent mechanism should be baked into a design from day one. So as you can see on the slides, you'll notice that while the utility of PBD is clear, it's proactively prevents privacy breaches. I mean, the challenge lies in its implementation without clear standards. Many organizations risk treating a PBD as a checklist rather than a comprehensive, genuine, and commitment to protecting users' data. So I find that this principle pushes companies to, I mean, innovate responsibly. Okay, though it depends continuous oversight to ensure that design privacy isn't reduced to tick box exercise. Next, moving on the right to erasure. Okay, so it is also known as right to forgotten. Okay, so it is actually written in Article 17 of GDPR. So this principle empowers that individuals to request that their personal data be deleted when it's no longer necessity and necessarily for the purpose it was collected, or if their consent is withdrawn. So think of it as a way for individual to, reclaim the control over their digital footprints, removing outdated or irrelevant data to protect their reputation and personal autonomy. So, implementing this right presents a significant challenge, as we all know, as illustrated on this slide over here. So, on the major difficulty is that data can be spread across multiple systems and backups, making it technically, challenging to completely erase all the copies. And additionally, there is an ongoing debate about balancing this right with freedom of expression and the public's right. Okay, so how can I explain this? Despite these complexities, the right to forgotten represents a powerful tool for data protection in an era where information can persist. indefinitely online, right? Here comes lastly, let's consider data portability as defined in the Article 20 of GDPR. This principle actually allows individuals to obtain their personal data from one service in a structured, commonly used, and machine readable format, and to transfer it to another service without the hindrance. Okay, essentially, it gives users the freedom to move their data, reducing vendor lock and and encouraging healthy competitions among service providers. And on the other side, you can uh, see that the data portability is designed to empower users, providing them control over their data, and it also presents technical hurdles, and it ensures that between these systems is a complex challenge, and there are inherent security risks when transferring a large volume of sensitive informations. And despite these challenges, data portability is a forward-thinking concept that foster innovation and user autonomy in a rapidly evolving digital landscapes. So, from my personal perspective, I would say I believe these principles represent the next evaluation in privacy protection. I mean, they empower individuals and create more dynamic, user-centric approach to data protection. And however, as promising as they are, okay, right now, we must also address the technical and regulatory challenges they present to ensure that they achieve their intended purpose without unintended consequences. Moving to the next slide. Uh, Now that we have explored global privacy principles, let's turn our attention to a topic that has a long sparked debate, privacy versus security, and examine how these two critical concepts differ and interact. So, to begin, security involves all the measures put in place to protect data and systems from unauthorized access and breaches. So, think of encryption protocols, firewalls, and intrusion detection systems that work together to defend our digital infrastructure. So, on the other hand, privacy is about controlling how personal information is collected and used and shared. So, it's all about ensuring that the individual uh, have autonomy over their own data and that their personal rights are respected throughout any procedures involving their informations. Okay. So, as we compare these two concepts, it becomes clear that while security is focused on defending against external threats, privacy encompasses as much as broader spectrums. And even with the state of art security measures, an organization can still violate privacy if it actually collects more than uh, that they want, or use that data in a way that people did not consent to. So this is why maintaining a privacy is often more complex. It actually depends on continuous oversights, adherence to evolving legal standards, and culture that prioritizing transparency and accountability, right? And as we can see over here on the slide, modern technology, I mean, actually generates data at an unpredictable pace. I mean, protecting that data isn't just a matter of installing the latest security software. It's also require robust policies and practices that ensure I mean, personal PI informations is handled appropriately at a very large scale at every step. So balancing these two aspects is pretty critical, and while strong security protects against external attacks, it is the ethical management and responsible use of data that ultimately upholds our privacy. And I would say, from my perspective, maintaining the privacy is particularly challenging because it involves continuous oversight, evolving legal standards, and adapting to new technologies, right? So in a world where data is generated at unpredictable rates, I mean, super duper fast, and ensuring that every piece of a personal PI information is handled appropriately required not only, I mean, technically safeguard, but also the robust policies and the culture of accountability is also mentioned over there. So that was all about the privacy and security. Now, next, I would like to discuss privacy impact assessments, PIAs, a crucial process for identifying and mitigating privacy risks before they become a systematic issues, right? So, ideally, PIAs should be conducted during the design phase of a project. I mean, before any personal data is connected in, right? And as I remember, in right here in Canada, federal government agencies are required by policies to carry out PIAs for new or significantly modified programs. So in the private sector, although not legally mandated by PIPERA, but PIA are also strongly recommended as a best practices for that. So key, let's talk about the key findings. I mean, which are reveal issues, which can reveal issues. I mean, firstly, I would say over collection of a data beyond what is necessary for this stated purpose. Second, I would say inadequate consent mechanism or unclear privacy notices. And then I would say unclear data flow and accountability, which can lead to unauthorized data sharing. Right. So I personally believe that PIAs are indispensable tools. Like they force organizations to think critically about privacy from the outset. I mean, reducing the risk of the data breaches and fostering trust among the users. The proactive nature of the PIA can save organizations from a legal, financial, and the reputational damage in the long run. So that was all about that. Now let's talk about our final theme, case study. So I did a case study on a PHIPA investigation report, which was mentioned in the in the PDF. I'll mention over there as well. So let's dive into the real world example that actually ties together many of our class discussions. Okay, on privacy search evidences and something like that. So for this case study, I have chosen a privacy investigation report. Okay, as I mentioned, and in this particular report, the Office of the Privacy Commissioner of Canada (OPC) investigate a major breach involving mishandling of a person's health information by a healthcare organization. The investigation was launched following multiple complaints from patients and advocacy groups who were concerned about the unauthorized access to their confidential health records. And there were some key elements as well. So let me first talk about that. Background and trigger. First key element of ours. So, investigation was initiated when several patients reported that their sensitive health data, such as medical histories, diagnosed reports, and treatment details, had been accessed by the unauthorized persons, or we can say attackers. So, these complaints suggest that systematic weakness in how the organization managed and protected personal health informations. Second is scope of a review. The OPC conducted actually uh, what I can say. Um, I mean, they conducted an in-depth review of organizations' internal data management practices, And this actually included scrutinizing data like access logs, reviewing the technical and administrative security measures in place, and evaluating the organization's privacy policies. So the report, actually identified the significant lapses. For an instance, there were multiple instances of employees accessing patients' records without legitimate need to know the basis, and the organization's technical safeguards such as encryption and access controls were found to be inadequate. So uh, basically, the key findings, I mean, we find over here is like unauthorized accesses. Okay, mostly the patient's records were accessed by the individuals without the proper authentications, the first thing. And it is also found like the technical infrastructure lacked robust encryptions and did not employ the regular security audits, leaving the all the data vulnerable to everything, right? And the internal privacy policies, let's talk about that, did not align with the high standard mandates by FIFA. Okay, and the organization failed to provide the clear notice to patients about how their data was managed. And lastly, I would say patients were not sufficiently informed about the handling of their personal informations, with further eroded trusts. Right. So that was all about these, OPCs and the key, key findings. Now let's just talk about contextual analysis. Okay, so this investigation report resonates deeply with several key themes. Okay, so we have actually covered in this course. So first is a privacy. So at the heart of this report, the principle of that personal health information is extremely sensitive and must be treated with the highest degree of care. And our class discussion, the video discussion over here, whatever we did, it actually repeatedly emphasized that the privacy is not just a legal requirement, okay, but a fundamental human right, as per the Canadian government and the European government. Okay, so the unauthorized access and the subsequent mishandling of patient data, in this case, represents a clear violation of the rights. Okay, we clearly see that. And the report underscores that even the sector with highly regular regulatory oversights like healthcare, maintaining a robust policies, privacy protections is challenging. The second is search and evidence. So while this investigation does not involve a traditional law enforcement search, the principles are similar. Okay, just as evidence obtained through unlawful search can be deemed, okay, internal access to, sensitive data without a proper authorization and authentication is a breach of legal and ethical standards. And the investigation illustrates that the data, like if accessed improperly, loses its integrity and can undermine the trust in the entire system, similar to how unlawful obtained evidence can compromise a trial, right? And third is computers security. So computer security, what I can say, I mean, uh, this is actually a significant portion of the report, I would say. I mean, it actually contains examining the vulnerabilities of the healthcare organizations. I mean, weak encryptions, insufficient access controls, and a lack of regular security audits were all cited as the contributed factors to the breach. And this actually aligns with the information we covered till now on the computer security, where we learned that the robust technical safeguards, uh, I mean, must work in hand with strong administrative policies. I mean, The report provides a clear example of how lapses in computer security can lead to major privacy breaches. Right. Last, here is interdisciplinary integrations. So, what I find particularly, compelling is how the report does not isolate privacy, security, and policy failures as a separate issues. Instead, it actually shows they are interconnected. A failure in one area can cascade into a sorry, full-blown data breach. So this holistic perspective is something we have emphasized in the class in this in this whole class. Okay, understanding that protecting personal information is an interdisciplinary effort involving legal standards, technical safeguards, and the robust organizational practices. Okay, so that was all about this. Now let's talk about personal critics and reflections. Now, I would just say let me share my personal critics to this report. I mean, there are some strengths. Okay, so first I would say is comprehensiveness. So I was impressed by the depth of the investigation. Okay, the OPC did not merely identify isolate incidents of unauthorized access. They conducted a systematic review of both the technical infrastructure and the administrative policies. So this comprehensive approach is essential in understanding the full scope of privacy risks. Then actionable recommendations. The report goes beyond the what we can say diagnosis by offering clear practical recommendations, such as suggestions like updating privacy policies, enhancing encryptions as we talked earlier, and intuiting regular audits and concrete these steps that the organization can take to mitigate the future risks. And lastly, it comes a link to PHIPA. Okay, so the analysis is very grounded in the legal requirements of FIFA by closely linking the finding to statutory obligations. The report reinforces that the importance of the compliance and and it actually provides a strong legal basis for its recommendations. Right. There are some areas as well where they can improve, like enforcement details and comparative analysis. Okay. And when I just talk about enforcement details, I would say one area that could be expanded upon in reinforcements of the recommendations. While the report provides an excellent roadmap for remediation, it would be actually beneficial to include more details on how the organization's compliance with the monitored over time, and what penalties might be imposed for continued non-compliances. Right. So that was all by my side. Thank you so much for connecting with me. Have a great day.